Wambui, Shadrack Wambui. I equally serve as one of the advocates that has been long been representing Mr. David Mokaya. While we applaud and appreciate the judgment that was read out yesterday, acquitting our client, Mr. David Mokaya, of all the criminal accusations that were levied against him, we have taken a further step to reflect on the process that led to his arrest. You will recall that Mr. David Mokaya was arrested on the 13th day of September, 13th day of November 2024. The circumstances leading to his arrest are very interesting, and that is what we are basing on to levy certain accusations against Safaricom as a corporate entity. On the 13th November, when he was arrested, there was some investigations that were conducted that led to him being arrested from his hostel in Moi University. So one prosecution witness, the fifth prosecution witness, Mr. Daniel Hamisi, who works at the security department of Safaricom, testified that they gave out data belonging to Mr. Mokaya from the 13th day of September 2024 to the 14th day of November 2024. And it is this data that was used by Safaricom, by the DCI officers, the DCI officers to trace Mr. Mokaya's whereabouts that led to his arrest. The constitutional question that is before the court as we speak, of course reflecting on these circumstances, is what is the process that led to the arrest of Mr. David Mokaya? Was that process legal? Was it constitutional? Did the DCI officers obtain the evidence that led to his arrest lawfully? So the conclusion that we have respectfully arrived at in view of these circumstances is that the material that was obtained by the DCI that led to the arrest and the prosecution of Mr. David Mokaya was evidence that was obtained illegally. It was obtained illegally because Safaricom volunteered to give information pursuant to a letter that was written to them by the DCI without taking into consideration that there was no court order that directed Safaricom as a corporate entity to give out that information. So it is for that reason that we find reason to prosecute Safaricom for illegally sharing information or unconstitutionally sharing information with the DCI that led to the prosecution and the arrest of Mr. David Mokaya. So if not for anything else, this is first to serve as a lesson to Safaricom as a corporate entity that they can be a criminal as an artificial body. So as an artificial body created by a law or statute, they have participated in a criminal activity that led to the constitutional violation of the rights of Mr. David Mokaya. And for the violations of the rights and fundamental freedoms of David Mokaya, it behooves Safaricom to adequately and promptly compensate Mr. David Mokaya for the violation of those rights. Secondly, because Safaricom is not the only corporate entity that will find itself or has found itself in such a situation, or has been invited or will be invited for that matter by DCI or the investigating officers or investigating agencies within this Republic of Kenya to share certain information. It is important that we instill certain lessons in all corporate entities within the Republic of Kenya, so that if Airtel or Telcom or whichever entity that there is, even Safaricom moving into the future, is invited to participate in these constitutional violations as they have done or as they did in the case of David Mokaya, then they will live with the fear that they are not above the law, that they are subordinate to the Constitution, that they have a constitutional duty to protect and to preserve the right to privacy of each citizen. It cannot be proper that Safaricom only through a letter written by the DCI will volunteer personal and private information of the people living within the Republic of Kenya. So this should and will be a lesson to Safaricom if they do not heed to the demands that we have enumerated in our letter dated the 19th day of February 2026, then in the fullness of time, we will be taking action to commence the appropriate civil action against them so that Mr. David Mokaya can have his rights addressed, can have some legal redress for the violation of his rights. Over and above that, the DCI, of course, as an agency within the Republic of Kenya, did not do a proper job. They subjected Mr. David Mokaya to what we call malicious prosecution. Malicious prosecution in the sense that they knew too well that there was no evidence linking Mr. David Mokaya to the publications that were alleged were done by him. It is for this reason that the honorable magistrate acquitted him under section 215 of the CPC. So equally, we will be taking action to sue the state for the malicious prosecution of Mr. David Mokaya, so that those state officers that commenced these malicious and legless charges against Mr. David Mokaya can equally take responsibility. They must be accountable for their actions. It is not enough that you arrest someone's child, take them through a very thorough or rigorous process that leads this individual to being arraigned in court, prosecuted for a number of times. Had it not been for the generosity of my senior, Mr. Danstan Omari, he would have even incurred unmeasurable costs in terms of legal fees. But we thank our senior. We want to thank the members of the press, for the state, for always standing firm and ensuring that we share this information to the rest of the Kenyans and the world at large to see what is happening. I have said so much. I will pave the floor to my senior who will address you with regards to these matters. Thank you.